Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk, Chris, and Ted's Excellent Adventure Call-In Show. Please welcome your host, Kirk Pendergrass.
Good evening, folks. Cold as can be over here in Idaho. We got like 25 degrees here and chilling as we speak. So
ouch.
I hope you're staying warm out there. And those of you probably over on the lower east, lower southeast, or Florida over there, nice and warm. Got some family, friends of the family down in Arizona. They're talking it's like 75 degrees down there. Lucky you, lucky you. Thank you for tuning in tonight, folks. It's a call-in show. It's the Kirk, Chris, and Ted's Excellent Adventure call-in show. So this is what we're putting out there is the need. We see the need. Trying to separate the two shows. Kirk's Law Corner on Monday night is the education part, and then Wednesday is the call-in part. So we're doing this for you. I would like to start off with a public apology to my friend, brother Chris Hallett, for Monday night's harassment or whatever, however you want to say that. And you don't quite understand jurisdiction, but I still have an argument, and we'll talk about that. But what I did was after the shows, I went back and I listened to that portion of the show there, and I also noticed that I was looking down, which I was trying to read the phone and try and read some of the comments. So I didn't actually catch fully what you were saying. So I got a chance to listen to exactly the words that you were saying instead of just kind of hearing it in the background, because I can do that. I can listen on one ear and read something else. I had ex-girlfriends get pissed off at me because I've got my eyes glued to the screen and they'll ask me a question. I turn around and answer it and then go right back to reading. But so sorry again, Chris.
That's all right. Hey, mistakes happen, brother. Mistakes happen.
I have my knee-jerk PTSD kick in sometimes. So,
well, we all do. In this situation, is it any wonder?
Well, and the thing is with what I was specifically irritated with was the fact that you were telling people to move, not necessarily move courts, and I understood what you were saying there, move it to the jurisdiction, but per the rules of procedure, you have to file your notice of special appearance. What that does is you're objecting to the jurisdiction right there in your paperwork before you even go to court. And so this is what I teach is the notice of special appearance, objecting to the personal jurisdiction, subject matter jurisdiction, the cause of action, all of that good fancy stuff with the affidavit of status.
Mm-hmm.
And what that does is it objects to the jurisdiction and it brings in the jurisdiction exactly what you were saying, which is the Article 3 courts. But the way I have it set up and according to the rules of procedure is that's what is done in the very beginning. So I'm not going to move to an Article 3. I only consent to an Article 3. I wrote it down in writing in plain English for you to read. I'm here to argue that there's no jurisdiction here. So you have to prove the jurisdiction first. So that's my argument with.
Well, the reason for doing it orally, because remember, there's two ways to move the court. You know, most everybody, the first thing they want to do is go to filing a document. So when you file a document, but the court doesn't answer it or doesn't address it, you can restate it verbally when you walk into the court, which is what I was talking about, because I've been down that road more than once.
Me too.
And, you know, like you said, you know, filing your special notice of appearance or your, you know, your affidavit of status, blah, 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 blah. For me, I do follow up. You know, I you know, in my field, we're taught to inspect what you expect. So what we expect is what we file. The inspection part is when you walk in and you ask for verbal confirmation, right? And if there still is no answer, then you basically give the motion again verbally. So if, you know, this is one of the problems that, you know, you run into when dealing with certain practitioners in certain courtrooms. When they don't want to address a problem, they'll do everything they can to skate around it, right?
Oh, yeah.
Half answers, no answers, half-assed answers, completely deflect the question, which, of course, you know, watch a political debate. It's the same shit over and over and over again.
It's all about deflection, isn't it?
Yeah, exactly. So, you know,
especially when they answer your question with another question. It's like, no, answer my question first.
Right.
And then part of what I teach is the fact that we have to make our record, and it has to be in and on. In meaning your paperwork, which half the time they don't frickin' pay attention to or don't want to acknowledge or address. But then you go, wait a minute, I've got a right here where it's clerk of the court stamped was filed on this date and this time. Did you not read my paperwork? Okay, well, that's fine that you didn't. But why don't you pull it out of your file right there? Oh, wait, if you don't have one right there, I have a copy for you right now, which I always bring copies with me. So here you go.
Both. Paper's cheap, brother.
Turn to page 3, notice of appearance there. You know, and then if you'll look at page 4, my affidavit of status, I don't consent to this jurisdiction. I only consent to the common law jurisdiction. So this court lacks personal jurisdiction and subject matter jurisdiction. And, you know, something I'm adding to my little argument here is, oh, yeah, you see that Admiralty flag there behind you? I'm a Marine Corps veteran. I know exactly what that flag means. And I do not consent to that jurisdiction. Plain and simple. And I'll take you to
right. And as you served, you can cite your DD 214.
I do have my DD 214.
Correct. That's why I said, so you can say that I'm no longer, you know, in the Marine Corps. Here's my DD 214.
Yep.
This is not the proper court, not the proper venue, forum, whatever you want to call it, to hear this matter.
And I'm definitely adding that word standing in there. You know how many times, I'm sure you do the same thing, try to go to sleep or something, and all this shit just rolls through your head. And I've already kind of got it worded how I'll what man here has standing to bring this cause of action, which would give this court personal jurisdiction or subject matter jurisdiction here today, Your Honor.
Mm-hmm. And the funny thing is, too, you know, you can think about that when anybody who's been married in a church, the priest always says, should anybody have any objection or should reason why these two should not be wed, please speak now or forever hold your peace. Right. Yeah. So he again is asking for anybody withstanding. Yeah. Right. So ironic how that works out, isn't it?
It is, isn't it?
So yeah, the the irony. Oh, the irony of it all.
We have a caller.
Yes, we do, Mr. Darren Mikowski.
For this show, I need all co-hosts, so all of us can see the callers.
Okay,
that sounds like
awesome.
Mr. Darren Mikowski, how you doing, brother, out in Pennsylvania? Oh, you know what? I suppose I better unmute him. Why won't it let me unmute him?
I have no idea.
All participants are unmuted, it says.
It won't let me unmute him.
All right, let me make you the host of this, and then you make the rest of us co-hosts. Maybe that's the way to do this. Testing. So Darren M, are you with us?
I can't unmute him. Maybe he's just listening.
That's possible. Maybe he just wants to listen. I can't unmute him either. And now he's gone. All right.
Yeah,
he may call back.
All right.
Hopefully we're not.
We tried, man.
Yep, we did the best we could on that one. All right, Kirk, you're now the host. Chris is
Thanks,
a co-host. Sir. You just need to make me a co-host if you'd like, and we'll be all set. That way everybody can see the people who are calling in. Everybody meaning you, me, and Chris.
Right.
Oh, well, I don't know about you, but oh, there he is.
He's back.
I heard the little ding dong. Shows that he's here.
I can't
It will
unmute
not
him.
let me unmute him.
Oh,
wait,
there
it goes.
Ah.
Darren, are you with
back.
us? All right. How you doing, brother?
I'm sorry, my connection. I'm doing all right. My connection's been really awful today, so I missed the first part of your conversation here because it was chopping in and out. But I'm interested to hear what's going on. So
I like this guy. He's
just
a
gonna
smart
hang out
guy.
in the background if I can.
Yeah, no problem.
Absolutely.
Darren's a sharp guy. I've been friends with Darren for over a year now, and we've had several lengthy conversations about law stuff. He's a sharp guy. I really like Darren a lot. He's having some rough times out there in Pennsylvania. So, seriously, people, this corruption is everywhere in every court that we go into in the land. It's not just family court; it's everything. Criminal court.
This is true.
Court, probate court, family court. It's because of the admiralty jurisdiction that's been extended back onto the land by congressional act in 1845. I don't know how else to keep telling people that that's the reason why we are where we are is administrative law.
Right. And, it's we go through these cycles. Remember, we were talking about this Monday night where it is.
Bicycles?
What's that?
Through the bicycles?
No, we go through these cycles, these power struggle cycles, every few hundred years.
Every 50 years out of 100?
Yeah, right. Not to be confused with Tron, where light cycles. Remember that?
Light cycles. Is that like a bicycle version of a lightsaber?
That's it.
Your bike, somebody pulls you over.
That new electric Tron bike? Seriously. Have you seen that?
What's that?
The new electric Tron motorcycle?
No.
Oh, God, no. I'm afraid of that.
It has like a 90-mile, 80-mile radius.
Oh, my God. Now, give somebody time. They'll figure out a way to put a solar panel on top of it and extend its jurisdiction.
Who put it out?
Declaration of Independence right here. For depriving of us in cases of the benefits of trial by jury as a declared act of tyranny. If you're in a case where you don't have the right to a trial by jury, well, if you look at the Declaration of Independence and what I am looking at, that's a declared act of tyranny.
Right.
He has combined with others to subject us to jurisdiction foreign to our Constitution and unacknowledged by our laws, given his assent to their acts and pretended legislation. There's another one here. He is, I'm trying to find the one where it says he talks about legislating for us. For abolishing the free system of English laws in the neighboring province, establishing therein an arbitrary government, and enlarging its boundaries, so as to render it once an example and fit instrument for introducing the same absolute rule into these colonies. There it is. For suspending our own legislatures and declaring themselves invested with the power to legislate for us in all cases whatsoever. that's where we're at right now.
Right.
The bar has infiltrated our government.
Yeah.
All three branches of the government. They are legislating for us. That's the thing. We, the people, are the first branch of government.
That's right.
We are the sole arbiters of law. We are the ones that are supposed to be passing this statutory law.
Right.
Not our representatives. They're supposed to be assisting us. We're supposed to go to them and say, look, I got this problem over here. We need to afford a remedy at law, in law, through statutory law, if we need be. If the common law doesn't give the remedy, then we need to make statutory law to create the remedy. Because where there's a right, there's always a remedy. There's supposed to be by law.
Well, where there is what is necessary is legal, which is a maxim of law. So if it's necessary to create a remedy, then it's legal to create a remedy. Yeah. So, you know, that's the ironic thing is we got somebody else here. Is it Crystal?
3317. That is Crystal, isn't it?
No, she's 77.
She's 801.
Well,
her.
They're with us. I just put you guys on, or you on mute, so when Chris and Kirk are ready for you, they will unmute you.
Yeah, I'm guessing. I'm going to guess that it's Elizabeth Ann.
Oh yeah.
She said she was going to call in.
Let's go ahead and pull her on.
All right.
You are live. Who are we talking to?
This is Elizabeth from Pennsylvania.
Elizabeth.
Hi, Elizabeth.
Hello, how are you?
This one's for you. No, I'm just kidding.
Hi. I've had this question for quite some time now, and I don't get any answers for sure. Like people say, well, I'm not sure. Anyway, my kid was kidnapped, and Francesca knows this, and she's on there watching you guys. Holly as well. We are trying to figure out where the jurisdiction is for my kids that were kidnapped. Would be 8 years ago now. I tried to file for custody here in my county, which is Mercer County, Pennsylvania. I was stopped by the kidnapper saying that I didn't have any jurisdiction here, and the judge agreed by saying that I didn't have any jurisdiction because the kids have been in school and doctors and everything else down where she lives. And she knows the judge that is biased, has a conflict of interest because the judge is a friend of hers.
Correct.
So where do I stand there?
Well, basically, the thing you're talking about is the word that I tripped over. And ironically, the county that I'm dealing with is an Ohio county. I think almost connecting that one is Trumbull County, Ohio.
Yeah.
And basically what they've done is they've secured these artificial advantages, right? And the constitutional word for that is an emolument. So what you need to do is you need to go in and cite every single one of these incidences, right, where they've used their advantage, point out the conflict of interest. You know, this one knows this one. There's a history there. There's your conflict of interest. Therefore, neither one of them have standing. You know, we keep coming back to that. They don't have standing to make such a determination because of there's a definite appearance of impropriety, which does result in an artificial advantage, which is an emolument. So, you know, it's funny that we haven't been speaking this word in 230 years. And the more we get into this, the more we understand why, right?
Right.
So we talk about things like, you know.
But Chris, if I could interject, that it
Sure.
doesn't really mean a lot to her right now, does it? We're pretty much waiting on your conclusion, correct?
Yeah. Like I filed for, I just filed the paperwork into, for kidnapping, fraud, brainwashing, blackmail, a whole bunch of charges that I just filed certified this week. So they should have it sometime this week yet. But the thing is we didn't realize that this was a real kidnapping until Charlene Angelesta or something like that. And then Francesca broke it out wide open into the public to show how it was real kidnapping. It was not medical kidnapping. It was a real kidnapping.
Yeah.
Right. So the first thing you need to do is, once you get the, if they deny it, which it sounds like they probably will, the first thing you need to do is file a notice of appeal and fight this out at the appellate level. Yeah. Now, the thing you need to make sure is on the district court docket before you get to the appeals level is anything you would want to say in court. Okay. So if you have, documentation that tells a story or a timeline, you tell that story, and in context of the story, refer to the document. Okay. The court recognizes something called an appendix. So you can take and put a cover page on there and call it an appendix, and it just looks just like a table of contents. Tab 1 is this document from this date. So when you're talking about it in the timeline, you say, see tab 1, and then keep going down the story, see tab 2, and so on and so forth. So this way, when you get to the appellant level, which it sounds like you probably will, everything that you've entered is on the table to argue at the appellant level. Now, the good thing about the appellant level in this situation, where they don't speak in district court, they've got nothing to fall back on at the appellant level. So you literally take and pull this, what we call an octave shift on them, where they come in and they make all these ridiculous allegations in the district court. Okay. If you get through a district court proceeding, but if you don't, you can basically state that this is not just an error. This is a deliberate, chain of events, right? This did happen. Right. So that's why when you talk about what you call the crime, okay, the process that they follow, everybody knows it as RICO. I'm sure you've heard that all over the place.
Yes, I have.
Right. The thing that they get at the end of that process is called an emolument. That's the actual crime. Okay. Now, the reason that, going back into the history, I've done some history on the research of the word. Basically, you got to remember back in the 1700s when we were creating all these documents, the United States did not have the dollar bill yet, right? We hadn't created that. So knowing that enrichments and currency came in multiple forms, everything from gold and diamonds to
coffee beans.
Coffee beans.
Coffee beans.
Right. There were all these different forms of payment, right? So instead of paying money or cash or gold or going down this long list, they used the word emolument. Okay, basically, it's an enrichment of some form. Okay, and we can take that and fast forward that today. So, for example, what do prosecutors get out of prosecuting people? Whether they're guilty or not, it doesn't matter. If they get a conviction, they get political clout, right? For that,
right? That
political clout, that's currency in government. Right. So that is another form of money that they exchange with, favors, and, this person is this and this person is this, and I can trade favors here and back and forth.
Hey, you guys, can we talk about?
There's been a lot of favors done in this case, like a lot of favors. Well, I was medicated when this woman walked into my house and had me sign a piece of paper saying it was a guardianship paper. That's fraud because it was not a guardianship paper at all. It was a custody
Let's talk about
form. Me being
one second, Elizabeth. Let's talk about how we go from the lower courts. What is the next step after the lower court? We know what we need. Pretty much anything from the lower court, because they will deprive you of your rights. You will not get justice. So it's almost automatic to go to the higher court. But when, during a case, can you file, and who do you file with in your state exactly, I think is what Elizabeth would like to know, if I'm correct.
Yeah, that's one of the main parts.
Yeah.
I did file, I put the certified letter in the mail for Attorney General, Department of Justice, the sheriff, the state police in her county. There was one other one.
Okay, so
I don't remember what the other one was.
yeah, basically, you know, our right to due process of law does not stop at the first court that we go into. Okay, other than
Right.
New York and maybe
Other than
some
New
other
York.
states, which recently found out. Thank you, that gentleman that was Daniel, I believe, talking about New York and how courts are set up. I'm going to say with Idaho, we have 3 levels of the district court. You have district court, then you have the Supreme Court of state of Idaho, and it's appellate court and the Supreme Court. So you have the right to an appeal. Always, no matter what decision it is, when you make a motion and that decision is made, if you don't like that decision, you can appeal it. That's your right.
Okay.
Now, whether you go to a higher court, if you're in New York, you may not go to a higher court. It may be within the same jurisdiction, but it's a different court.
But when can she file? During?
Yes.
Typically 42 days. You have 42 days to file an appeal. But you will, this is just in Idaho. I'm just going to go with Idaho on this because I know this one. Okay. So you need to read your rules of procedure at the level that you're at.
Okay.
And it will tell you how many days you have to appeal any decision made.
You have to wait for a decision.
And then, not only this, if you know that you made your arguments correctly and your paperwork's filed correctly, and the judge doesn't perform his moral duties and ethical obligations under the law and violates judicial canon law, those kinds of things, that immediately, right there on the spot when the judge denies, okay, that's actually depriving you of your rights.
Right.
So the right to a cause of action under Title 42, Section 1983, 1985, and 1986. So you want to, I mean, that's on law.cornell.edu. You can get the law. That's what it says. There's a little tab that says get the law, and go to the United States Code, go to Title 42, and it's like, I know it's 1983, but it's like Section 10 or 108 or 160, I don't know, something in there. But you have to go down, you'll see it over there. Sections 19 something through clear up to 2000 something. And it's civil rights. Okay.
Now, when if
that's
you
a court of law.
When
you go into the federal courts.
So she has certain instances within the juvenile court process that she's going through, and she knows before the case is over, because this is the thing with juvenile court, they'll string it along for that magical 15 to 22 months so they can foster your children out. So what?
Correct.
CPS, right.
And
so what,
that's where I'm going with this.
What Title 4E people are worried about is I can't wait to file an appeal until they make a decision. I need to file and go to the higher court freaking yesterday.
All right.
You file your appeal right away.
I can answer that question. I can get you there.
Cool.
So, you can request if the court take an action at any time, whatever the action is. Even if you walk in and say, "Give me my kids back right now," and of course they're going to say no. You drop a notice of appeal right then and there.
That's what they want to hear. Really,
that's what I just said.
You drop that notice of appeal right then, right there. It would behoove you to have it ready to go before you even go to court that day.
Right.
Right. And once you file the notice of appeal, okay, and you can ask the court, do you want me to file this with the clerks, or would you like personal service? And offer it. Okay. Yeah. So obviously you're going to file it with the clerk anyway.
Hold on. Wait, we got double talk. Hold on.
Oh, hang on a minute, Kirk. This is my realm. This is where I go. So, here's the real answer. You're going to have multiple copies of it because you're going to serve the court. You're going to serve the other party. You're going to take a copy to the clerk, and you're going to keep a copy for yourself. And the reason for that is you're going to maintain a timeline record. Okay. When you file a copy with the court, ask the clerk to also stamp your copy for you. They will. It doesn't cost anything. So when you take your paperwork home with you and you're putting together your brief for the appellate and or the federal court, because you can do these things simultaneously. Okay. And we'll get to that. So you'll have your paperwork time and date stamped in order for you. So remember that appendix of evidence that we're talking about? You're going to just keep building that. It's going to get bigger and bigger and bigger. Right.
Okay.
Well, I have a stack of evidence, so that's not a problem.
Oh yeah. We've all got it from floor to ceiling, girl. Believe me.
I'm telling you.
So whether you're in family court,
what happens? Brenda asked what happens when you're denied an appeal. Okay, due process of law does not stop there. You have to take it to the Supreme Court.
Right. That's called a certiorari.
A what?
That's called a writ.
This same judge has actually been biased and has conflict of interest. Also, in my youngest child,
let them, Elizabeth, let them play this out. So, if you're denied, like Brenda said, you can go to the higher.
Writ is certiorari, but go ahead, say that the way it is, Chris.
Certiorari.
Certiorari.
Yes.
Can you say it again?
Certiorari.
All right, let me note the time for Rule of
Judiciary. Kirk.
One more time.
Can you guys still hear me? I get this little window keep popping up on the screen.
How do you spell that? A-S-U? S-O-R?
You're going to make me dig out the big book, aren't you?
Yeah, let's see. Is this it right here?
C-E-R-T-E-R-I-O-R.
I'm getting there. I'm even putting my glasses on, and it's all your guys' fault. Yeah, let's see here. Getting all over the place.
Ossuary. E-R-T-I-O-R.
Is it ossuary?
Thank you, Brian Van Aken.
Ossuary. 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 Ossuary.
Is it ossuary?
C-E-R-T-I-O. Well, I guess
certiorari. Certiorari. Here it is.
Certiorari.
Certiorari.
How do you spell it?
Yeah, hi. It's C-E-R.
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 Yep.
T-I-O-R-A-R-I. Certiorari.
Yep.
I don't think I got that right.
Black's Law 10th edition, page 275, if you're looking at that.
All right. How do you spell it again?
C-E-R-T.
Wait, it starts with C. Okay, C-E-R-T.
I-O.
I-O.
R-A.
R-A.
R-I.
R-I.
Correct.
Oh, okay, so it's this.
Certiorari.
Certiorari.
Man, that's
Certiorari.
Like I said, I have a hard enough time.
Certiorari. Certiorari.
Hey, before I started this, I spoke 2 languages, English and bad English, so I think I'm doing pretty good.
This is from late Middle English, from late Middle English, from Latin.
I can read the English real well.
To be informed.
Spell it.
To be informed.
So it would be kind of like a writ of mandamus.
Crystal.
Mandamus.
There's our
girl.
Certiorari.
Yeah, finally. Sorry.
Certiorari.
So it would be kind of like doing a writ of mandamus, where you're asking the court to review it and give an order to the lower court to do something specific.
Correct. Writ of mandamus is basically, hey, do your job, stupid, right?
Right.
Yeah.
Yep.
So, and again, that's one of the reasons why, remember, at the district court, you want to enter as much as you can, okay? And you want to argue as much as you can in the, at the appellant level, okay?
Certiorari.
if the
somebody likes that word apparently.
Right.
It rolls off your tongue like French.
I'm gonna have to start giving vocabulary words for these classes.
Now, see,
Really?
here's the thing. My Black's Law 6th edition here. It says to be informed of a writ of common law origin issued by a superior to an inferior court requiring the latter to produce a certified record of a particular case tried therein.
Certiorari.
In order that the court issuing the writ may inspect the proceedings and determine whether there have been any irregularities. So this is why I keep saying you have to file your paperwork in the record, and you have to make your oral arguments on the record, because there they're asking for basically that's what this does. I'm not even going to try and butcher that word.
It would be like taking an order to the appeals court.
Hold on. Okay. So what they do is they request the record, the written, well, it's not written, it's the transcripts. Okay. And these judges, okay, are going to listen to what you said on the record. That's what's called transcribe. They transcribe the record. Back in the day, we used to have stenographers that came in. And that's another thing you can do, Elizabeth. You can notify the court, basically request that you bring in your own stenographer. You pay your own stenographer, so you don't have to pay their exorbitant fees for the transcripts. You pay the stenographer, $200 an hour. You'll be better off paying the stenographer yourself and having them transcribe it for you than you would going in and spending thousands of dollars trying to get the transcripts from them, because they're just there to make money.
And every court has a list of stenographers that is available through the clerk's office. So, yeah, if you can.
But verify with your state, though, guys, before you tell somebody to do that, because, like in the state of Utah here, you cannot use a stenographer anymore. Everything is done audio.
Well, again,
no, you have the right to bring in your own. Right, it's a right.
Each court, each state has its own preferred methodology. Now, what you can do is you can argue that and state that you don't necessarily trust the effectiveness of the technology. So you can rebut that at any time and get them and make them admit a stenographer.
Yep.
Because like Kirk says, that's what's written in the law. Okay.
It's
so
right.
you request it. Yeah. If you request it, they don't grant it, that's cause for appeal.
Yes.
I'm just going to go there. If they deny, there it is, deprive you of that right to exercise the claim and exercise of a right can't be converted into a crime. That's Miller versus Lewis. But you have the right to say, I have this right and I want to exercise this right. Are you depriving me of this right, sir?
Which is protected by the 9th Amendment.
And put that on the record. Ask that question.
Right. It seems basic and rudimentary, but this is one of the things that we talk about. There's differences between paper law and trial law. So when you get ready to go into your proceeding, you have your list, okay, your bullet points, your cheat sheet, whatever you want to call it, of talking points, right? There's a word you hear all the time, your talking points, what you want to talk about.
Mm-hmm.
And you can provide copies. See, I'm a copy freak. I give everybody copies of everything. This way, nobody can say, "Oh, I didn't have a copy of that." Even the judges would look at them and go, "Oh, bullshit! I know better than that with this guy." So, I have developed quite the reputation with being here's paper, here's paper, here's paper. So, when I go in and I go over what my talking points are, there's no surprises. There's no nobody said, "Oh, this this is going to be a gotcha question." No, it's not. I say gave you service on it. It's right here. If it's a gotcha question, then you've got the problem, not me.
You got your problem.
Okay, let's. We do have another phone call here. 3058. You are live with us. Who are we talking to?
Hello.
Hello. 3058.
Hello. Is it Jody?
3058. Welcome to Kirk, Chris, and Ted's excellent adventure call-in show with Crystal Bills. Hello. Thank you for calling. Who are we speaking with, please? I think she hung up.
No?
Oh, it says she's there.
All right. Well, we'll put that one back on mute.
All right.
Well, I guess we'll bring Elizabeth back on here for just a second and see if we answered your questions. Elizabeth?
Yeah, I'm here.
Okay.
Yeah. Yeah, that was definitely very helpful. I've just been like dumbfounded on any of this stuff. Like, I was Amish. I don't know any of this stuff. And that was why I was such an easy target. I was medicated at the time, and it's like, you know, she'd see me coming a mile away. So, yeah, this did help. I'm sorry?
They do prey on people that, I don't want to say weak, as in physically weak, but, you know.
Mentally, emotionally, physically, all of the above.
Right.
Right.
All of the above. They don't discriminate. Men, women, it don't matter.
Yeah.
And that's the thing. Like, my case is not a CPS case at all. It's
none of ours
a
are.
person that walked in my house and stole my children while I was medicated.
Right.
That's why I don't understand why it has to go into a court even in the first place, because she took that paper into the judge to have her file it as a friend. You know, that's fraud in itself.
Oh, yeah. Fraud upon the court.
Right.
Yeah.
And that there in itself is an independent action. I mean, you could start a whole new case just based on fraud.
That's what I thought. Okay.
Which, in my opinion,
yeah.
That's the way I would go. For me, is that, and actually that is where I'm going. I'm going fraud upon the court. That's how I'm taking my family law case to trial.
So is it possible to say fraud on the court because of bias and a conflict of interest, or will they just laugh at me on that?
You can recuse
Absolutely.
the judge.
How about the process that was done? Okay, that's bringing fraud upon the court, because the process that they did, which was actually in violation of the supreme law of the land, let alone your state constitution, the law of the land. I'm pretty sure it prescribes a process that is due to you. And that process.
Yeah, it says on that paperwork that I have visitation rights, but I haven't seen my kids in 6 years, almost 7.
Right.
Right.
She won't let.
Just to answer.
I'm sorry, since I came in late.
Let me answer a real quick question here. Brenda Johnson asks on the comments, what is the motion when you need the judge to unseal a case? And the answer to that question is called a petition. You need to petition the court for that. So, and I'll get to the status of seal on my case shortly, because it's going to answer a lot of questions for a lot of you guys. I know it's it can appear to be kind of overly, crazy when you start looking at some of these documents, and they're a couple hundred pages, but I've broken it down for simplicity's sake, not just for the courts in my case, but also for anybody who wants to read it. And believe it or not, my concern was, would my kids be able to read this and understand it? Right. So I figured, you know what? There's going to be a day they're going to want to read it. And when that day comes, I want to make sure they're able to understand it. So that's why when I write like I'm talking to one of my kids. So
thank you, Chris.
I suppose that's the way to do it.
Yeah. So basically it's the good news is it looks like U.S. versus Congress of Florida and Congress of Ohio is going to be unsealed. That said, I've agreed to redact the information the judge requested.
Nice.
This way, more people can get a look at it and be able to take advantage of using it, that type of thing. yes, it would be nice to be able to keep this between us, but at the same time, that's not a privilege I'm going to enjoy just because of the magnitude of the situation. So
Right.
I've decided to go ahead and comply with the judicial request and unseal the case. So that's the reason I asked that question a few days ago.
And just so you all know, you can get a Pacer account, okay? And you pay for what you access, okay? So on the Pacer account,
You actually don't have to pay for access to it. Do you guys know that? To a LinkedIn account?
I know. Come on.
It's free.
So on the Pacer account, you can go in and you can view cases, and Chris's would be one of them. Okay. So when you download the specific case, so what you could do is you can kind of look around to find cases that are similar to yours that have won, and you download that Title 42 case or that writ of certiorari.
Mandamus.
You can do a search for those, and you can find those.
Certiorari is different than mandamus, Crystal.
Right.
I know.
So what you do is you can download those things that you find that are very similar, which would be the merits of that case. The merits of that case, if they match your case and that case won, okay, you're golden, because now you already have a case that's won. And if your merits match those merits, they're, you can say, hey, well, this is how you ruled last time in this case. And you use that as case law, which is, that's the common law, which is full of stuff. And right. But they're full of shit.
Did you say bully?
The common law is bills of attainder, and that's plural. There's lots more than just one, not bills of attainder, bills of rights.
Right.
Bills of rights are the common law. Declarations like the Declaration of Independence, the Declaration for the Necessity of Taking Up Arms of, July 6, 1775. Those are rights. That's the rights of common law. That's the common law. Rights that are common to all. And those are all
what is
following
going on here?
property. All right, what do we got going on here?
Got some crosstalk going on here.
So that's the common law. Rights, your property, right here. I've read it right out of my own Black's Law Dictionary. Property. Our rights are our property, our creator endowed rights, as declared in the Declaration of Independence. All of the bills of rights, those are all fundamental rights at the common law. And this is what I keep trying to put out there is we live at the common law. Okay? Do no harm. Do not cause injury or harm to another human being. That's the common law. So when somebody violates your rights, it's a trespass upon your property and a deprivation of a right.
Kirk, if we live
that creates the right to a cause of action. That gives somebody the standing to bring an action against you and claim that injury or harm to them.
Where does the lower courts live?
If you don't have that,
I don't know if anybody will get
a lot of people don't know.
But if we live at the common law, if you and I live at the common law, where are the lower courts living?
Admiralty.
What?
That's administrative.
Admiralty.
Yeah, Plupitor.
Okay.
That's the gold fringe on the flag that when you go into the court and you see that gold fringe on there.
And
that's an administrative
There's
court.
nothing we can do about that. As far as individually going into a lower court, there's nothing we can do about that. We just need to realize that can we expect, like, the first day you go into a lower court, if you go into a lower court that morning, can you then turn around that afternoon and file an appeal in a higher court? You most certainly can. Should we all be doing that? Said, you can even have your appeal ready right there in court. And when the judge denies, you say, do you want me to serve this to you now? Personal service? How do you want me to do this? Should we then, as soon as the bailiff says, please everybody stand for judge gonna rip your fucking heart out, should you then stand and have your paperwork, and as soon as he opens your mouth and says, please be seated, should you then say, wait?
An appeal means they took an action. You're saying that the action was wrong, or was an error, or was a trespass, blah, 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 blah. So you can't appeal a decision that hasn't been made yet.
I'm trying to make this as fast, like as expedited as into the court. They took his kids, his family's kids, like that. Even because of philanderings that happened when he was 17 or 18, old enough to be in the adult record, 10 years prior to his kids being even born. That's what they used to take his kids, and they had the governor actually. It's insanity. The lawyer in the case asked the governor to appoint a different judge to the case. That judge was appointed, took their kids, then reappointed back to the prosecution where she originally was. So I'm just wondering is there a magic word? When can we know, for somebody who has no idea, no understanding of the law, what is the magic word you can hear to be like, all right, this is done, I might as well leave now and go file this?
Okay.
When the gavel comes down,
three people talking.
But,
stop.
Bugs Bunny tried that one. It didn't work out so great.
So the
answer to your question is,
I guess you're a primary federal lawsuit. Have a nice day, sir.
Well, what is the magic word?
The magic word is you are now a primary named defendant in a federal lawsuit. Have a nice day.
From the judge. From the judge. What is the magic word?
No, the final judgment is.
Not in a case concerning Title 4E. Final judgment can't wait till the end. That's the thing.
What you do is you file what's called a notice of federal removal, right? And you cite what they just did as a trespass of law under 1983, right?
But what I'm asking is, for these people.
Hold on. You want me to explain? I got to be able to breathe as I'm talking.
But I'm not sure you're understanding the question. What I want to know is what people are asking me, because I don't understand, is when I go into court, what words do I need to hear from the judge so I can go file an appeal? What
You've
words?
been denied. I dismiss.
Right. Any denial, any action taken by the court. Yeah. Right?
So anything, like if you go in, if you're going in against CPS in juvenile court, and you know that, I mean, we know that your kids are going to be taken no matter what, but you're going in for the first day, and you want to file an appeal after that first day, or not after, I mean immediately after, on the same day. When that hearing is over, you want to go in your car to the appellate court and file. Can you just do that automatically, or is there a magic word?
Time out. Stop. You're on a tangent. You're on a soapbox. Stop.
I need to hear that magic word.
All right. Hang on.
Yes.
These things you already know. Okay? You've got it on good authority. What are some preemptive measures you can do? That's a damn good question. Here's what you can do. Two things is you can go make a police report. Tell the police what you know, right? How you know it, why you know it, the timeline, etc. Make them write what's called an intake report. You walk in and do it. Don't make them come to you. You go to the cop shop, where the police station is, and you write a report with the intake officer, man or woman sitting there at the desk, because they all have one, and you fill out an intake report, either with your state, local, and or you can even do this with federal law enforcement if you have one in your local area. And me being me, I start at the top and work my way down. I started with federal and went back and did this with the, well, here in Florida, we use the sheriff's office. So I went into both the federal, the FBI's office and the sheriff's office, gave them the same information and got their reports, got their numbers, went back and got their reports and took their reports to court ready in my hand, and stapled to the top of those was a notice of appeal and a notice of federal removal. I always do both. Some people want to do one or the other. I do both, but this is just me. Now, however you guys want to do it is, of course, entirely up to you, and it's your case specific. But know and understand, you can argue these things in more than one court at the same time. And we're doing it, and we're doing it effectively. Because what ends up ultimately in happening is in the federal court, you go in and you state this happened, this happened, this happened. This is your statement of claim, and it's ongoing, right? This ain't done yet.
Can I ask one more question while we're talking about this? How much does it cost, Chris, to file that appeal?
It depends on your state. Most cases in states, if they're taking an action against you, especially if it's criminal action, there is no cost.
So if you're in juvenile, there's a cost. So if you're in juvenile court, Chris, and you go into, because this is what I'm going to tell people. So you're in court for the first time, not family court, but juvenile court. I want to tell them to have their appeal ready to file immediately after that first court hearing ends, correct?
No. You can serve it directly to the judge and the other parties while you're standing in the room. So remember,
you don't
paper law, trial law.
So when the judge says, I hereby, we're going to recess until this date, you say, wait. What do you say?
Okay. You've already, now if you've got your police reports and everything in hand, you can hand those to the bailiff and say, I knew this was going to happen, and filed a report. This is a trespass of law. Okay. And you know, things I wish I knew at the time, but didn't, but I do now. And, you know, I walked in and said, look, this is a trespass of law. On its face, it is what it is.
Right.
So, and what ultimately ends up in happening is the judge says, you know what, I'm staying everything.
Interesting.
What does that mean? Nobody's doing anything until we get resolution. And the one thing they want resolution from is what the federal court's going to say. Right. So if you're going to do this, and you go to federal court, it'll be the best $400 you ever spend.
Yeah.
Because if you pay the money, they cannot turn you away, period, end of discussion. So and if they do, you can go directly to the federal appeals court. And as long as you've got everything filed at the district court level, you got them by the short curlies at the appellate level, and they can't waive or salute. Why? Because they didn't deny it. They did nothing. They did nothing. So you end up hearing what's called in de novo at the appellate level, and they've got no way to file an affirmative defense.
So to make this 100% clear, you go into court for the first time, and if you know anybody, you know, we are advocates. We're hearing these stories constantly. For me, like 10, 15 times a week, sometimes with horrible pictures, horrible videos, and they're asking you, what can I do? And they're saying, they're telling me I have a court case Monday, and I need to tell them, you need to have your appeal ready to file to hand to the judge before you even go into court, right?
I always do. I have every contingency I can think of prepared, ready to go before I hit the door.
I've actually seen people come in with like a big case full of freaking paperwork.
Yeah.
And the judge says something, he just reached over and he pulled, like, here you go, serving this to you right now.
I'm serving you.
Sign it, and then serve it to the judge.
Yep.
And then what do you need to do after you give it to the judge? Does the judge have to file it to the higher court?
You're actually giving it to the clerk who's sitting next to the judge. That's the actual clerk of the court.
Okay. And so
That's
what do they
next to the judge?
They don't
That's
crumple it up.
Runs the courtroom, by the way.
They don't crumple it up and throw it away. They will file it with the appellate court, or do you have to then go afterwards?
They can't crumple it up and throw it away. If they crumple something up and throw it away, that's a trespass, and that's instantly the bailiff can arrest them at that point. They're not going to be that stupid. You know, I understand everybody's, well, what if? But dude, what if a meteorite falls and hits us?
What do they do?
Yeah, what happens if the garbage truck takes wings and flies?
Sure, but after you give it to the judge, what do you have to do to make sure you have a court date?
Again, you're not giving it to the judge. You're giving it to the clerk of the court.
But
after the man or woman sitting next to the judge.
But
usually you hand it to the bailiff, and the bailiff hands it to either the clerk or the judge or both.
But how do you make sure you have a court date, Kirk?
When you walk out of court, you go over to the clerk's desk. Remember the extra copy I said you have?
Yep.
You ask the clerk while you're here, can you stamp this for me?
Okay.
This way I can keep it for my records.
Yep.
You know, remember, you're building your timeline. You're building your case, right?
Uh-huh.
You are, think of it as you're the forensic expert, and you're examining the crime scene, right?
Sure.
Give me stamp this with the time thing, with your lovely little stamper on it, and you can mark it copy or whatever you want. And you've got a documented record. That's an official record in your hand, and you keep it. Okay. So knowing when
you do if they refuse to do it.
So then
they will not.
If they refuse to stamp it,
they will not refuse to do it. If a clerk refuses, you request the supervisor. The supervisor will do it.
Because
I went through a similar case with a kid. I had video evidence of the brother doing heroin in front of him with 3 hookers. We had collected over 3 months of evidence. CPS came in and took him. Then all of a sudden, all the evidence on his phone was magically erased.
Yep.
All the hard copy evidence we had was destroyed. And when I went to court, I was told that because I am not of blood, that any evidence I have collected is useless. And on top of that, his lawyer and the mother's lawyer were related, and neither one excused themselves from the case. And the judge told me if I said another word, I was going to jail for, what is it when you disrupt the courtroom?
It's the lower court. Contempt.
I don't even know who that is.
Then they went after me for parental interference. I had to defend myself. I contacted a lawyer who told me if I give him $10,000, I am guaranteed the kid. All he has to do is grease some wheels with it.
Don't know,
and I live in a Commonwealth state.
You're in Pennsylvania, then.
What state?
Kentucky. Louisville, Kentucky.
Louisville.
You're in Mitch McConnell's stomping ground.
They make great bats.
Well, here's what you do. When you file anything with the court, number one, you never give them originals. You always keep your originals. And there's a reason for this. Now, whether it comes to you're going to present this at the state level or the federal level, doesn't matter. You're going to file copies with everybody. And it's the same copies with everybody. So if one of the copies gets corrupted at the state level, you've got the federal backup, and you've also got the original in your hand, right? So,
all right,
you only take originals with you here, and
I'm not sure.
The judge will ask you periodically, "Hey, let me see that." You hand it to the clerk or the bailiff. The bailiff hands it to the judge. The judge hands it back to the bailiff to give back to you. Okay. That's the way actual judicial procedure is written. Okay. And every judge will do that because they can lose their job. So
the judge I tried to hand the paperwork to, when I tried handing it to the bailiff and stuff, she told me everything I have is garbage. She doesn't want to see any of it. that it's not evidence. I was treated as if I was a criminal instead of a witness. And I'm not the only person in the city it's happening to. And I've kind of become an advocate for others. I've helped 2 families get reunited, but I don't know enough about the laws to help them correctly. And it sounds like you do. So I would like a little advice, and you're giving great advice right now.
I created an entire
first of all,
solve this problem.
Who are we talking to?
My name's Jay Heidelball.
And how are you talking on our show?
He called in.
I saw it on Facebook originally. There's a number at the top. I called the number, then punched in the key code.
Yeah, Zoom.
Okay, but
Zoom
I have everybody muted.
Zoom must have a glitch because
don't know.
Then I have no clue. The luck of the draw.
You gotta love these. You gotta love these algorithms.
The luck of the glitch, I think, is what's happening.
Apparently, I was meant to talk to you. I have no clue.
Well, anyway, it's okay. Doesn't matter. You know, hey, that's the reason we're here.
So trying to have a little bit of structure here, you know. So we'll just have people just blurting out and.
Yeah, Zoom.
Well, you know, hey, we'll work this out as we go. We're new at this. We'll figure it out. But this is actually a good. You know, this is a good one. You know, when you get into, you know, these things that have happened. Okay, you keep a log of all of these items, right? Every time there's a trespass, that's called a trespass. Okay, you can take and you can go. You can do one of two things. You can just create a log, keep it, or you can go file a police report. Every time there's a trespass, you can file a police report. If it's the same,
I attempted to. The social worker, her name's Amanda Knowles. She actually knows my family. Her and my sister used to get in fights when they were children. So she knew exactly who I was. And I called the cops several times to report, you know, this is what's happening. She knows my family. She needs to be excused. I talked to CPS supervisor and informed her exactly what was going on. And I was told I need to shut up and mind my business or I will be arrested.
Well, if you've been given a, you know, permission from somebody within the family to be a witness, technically speaking, nobody has standing to interfere with that. So, the fact
originally I went against the mother, so.
Well, hold on.
It was bad.
Somebody's attempting to interfere with permission you were granted. Okay, that's again another trespass, a cause of action. So, and it's all about how you present it. Okay, personally, I like to prepare reports. Here's the situation. Okay, here's everything that supports it, and here's the report based on all of this information. And believe it or not, that's actually pretty effective, more effective than I thought it would be. And because when you file things as a report, as a witness, okay, you're technically speaking, you're not asking the court to do a damn thing. You're saying, here's the trespasses. I witnessed these things, right? And I'm adding this to the official record. Now, if you do have to take it to the next higher level, excuse me, this is where getting it on the record comes in. All right. So you don't have to, I mean, if you have personal knowledge of a person, you know, this was my buddy, we were drinking buddies together back in high school. I mean, or played football together, I mean, whatever. You have an established relationship, okay, that is justifiable as to why you would be standing next to this person. Okay. So if in the event that these court actors, for lack of a better expression, and they love to interfere, I object, blah, 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 blah. Well, based on their policies, they have the right to do that. Well, not anymore, they don't. Not as of November 16th. So,
right.
Which is...
What happened at November 16th?
November 16th was the date that Jeff Sessions basically came out and said, your policies for your agencies don't mean jack shit to anybody outside of your agency. So for you guys trying to use these policies, these guidance documents to act outside of your agency, you're not doing it anymore. I'm shutting you down. So that's
thank God.
I mean, that's significant in and of itself. And there's a letter. I posted it in my group. Kirk's posted it on Kirk's Law Corner. We even watched, there's even a video there where Jeff Sessions read it to Congress. He explains the letter, what it means. You know, like we always say, the law says what the law says. These guidance documents are not the law, right? So quit trying to use them as law.
And he actually said that ends now, today, right, on November 16th. Those parliamentary practices, those ended on November 16th.
You know, it's funny. You know, I went back and watched that video again, and I had a copy of my report in front of me as I was watching it this time, and I'm flipping through my report page by page, and I could see where he would have, when he was talking, it was like he was reading segments from my report because it was verbatim what I wrote.
I was a little concerned because I had received a phone call. I started a petition in order to change the laws because they're doing what's known as legal kidnapping. They take a child from a home, place it with a foster family, tell you if you do certain rehabilitation, go to counseling, you can have your kid back. You always fail the first time, then the second time you pass. But there's a law in Kentucky that states if you're with a child for more than a year as their legal guardian, you can petition for full custody.
Right.
And that's what they've been doing. I got a phone call from CPS saying, I need to stop my petition or else. I have a lot to lose. I had it recorded and everything. I call the cops. The cops say because the number doesn't match, it could have been anybody from anywhere, some random person picking up the phone. It doesn't matter, and they're not filing a police report.
Well, now, if they don't file a report when you ask them to come to you, remember, you go to them. Okay, you can always walk in. We pay for that service, right? For them to protect and serve. You say, I want to file a report based on this documentation. Okay, I'm not asking you to go pick anybody up. I want a report filed to document this transaction, occurrence, or event. I want it documented with this law enforcement entity, because when the time comes to enforce it, where we may not be there yet, but when the time comes, we will have a report that shows what we want enforced.
I want to thank you. I reached a point in this fight where it's like I couldn't go any further than I could go. And you have given me hope that we can actually change this crap from happening to others.
Well, the good news is many of us, like myself, this is actually not my first rodeo with these people. This is my second family. I've been fighting these bastards for almost 30 years. So there's a whole time of experience behind everything that I've done. And when I hit the doors of these offices, these guys know me by name. They know me by face. I don't even have to speak. They know who I am and they know why I'm there.
Can we answer?
And
can we answer 7?
You know, it's ironic that these events have turned out the way they've turned out. But you know, the funny thing is when I'm actually get the orders from the court that allow me to publish it, I'm going to publish my indictment against these actors in my kids' group. So even if you don't have Pacer, you'll be able to go download it and read it for yourself. So
the city you're in, does the workers get a bonus for returning the child to blood?
No.
Those bonuses are gone as of November 16th. There is no more bonus. It's done. It's gone.
That's the petition that's the thread I got. I was trying to stop the bonuses.
There's no bonus for returning the children to their relatives. There's only a bonus for keeping the children away from family.
No, he's right. They did used to get that in some states.
Amanda Knoll got paid $150 for returning the kid to the abuser.
Right.
But
and then she took him again, and when she returned him a second time, she got another $150.
That's the part.
Every time they return them to blood, they got bonuses.
Yeah, that comes from the Title IV-E mechanism.
But see,
so anybody that's got a CPS case, I think Title 4D is screwed up. That's just the child support end of it. Title 4E, it's literally a transaction goes both ways.
Well, see, in Title 4E,
wherever they benefit is where they put the kid. And that's where they get most of the Title 4E money.
Let me clear
and every transaction, every one of those transactions doesn't even require any involvement. So that's one of the reasons why they push the Title 4D so much, because they can establish a payment history,
Mr.
right?
Hallett.
And
Hallett,
every one of these cases, based on that payment history, that goes to, well, what's this case potentially worth, right? So we talk about.
All right. So let me tell you about this. All right. Nobody on Zoom can hear me, or maybe they can, but none of them can talk. With Title 4E, there was something that that gave like this small incentive to returning children to families, but it's very small, $150. Now, if you put a kid with strangers, you're talking $20,000 a month. That's the incentive. So what ended up happening with that 150 is it just disappeared. It's still on the books and you can reference it, but nobody's going to give it any thought, because on the opposite side of that you have $20,000.
Brenda's been like, we got to answer this one. So 7864.
Yeah, how you doing?
Pretty good. Did you have a question for us tonight?
No, I was told to call in by Brenda Johnson. Me and her talked here a few days ago,
right?
About a story that I've been going through, and I'm not sure exactly what she wanted me to call in here for tonight.
This is we're supposed to have, answer questions here, trying to help people with answering
not a specific question related to a specific procedure or in a specific event that happened, and you don't know where to go next.
Yeah, when it's not really story time, we don't want to waste time. I mean, it's not wasting time, but
I'm kind of
talking about.
I'm kind of stuck in
history of the case.
Go ahead.
We want to help people. This is where I'm at.
Okay.
What do I do next?
Okay. Well, I'm kind of stuck in one part. I just did an objection in the court, and I seemed to put a little bit of fear into the judge, and he was actually a different judge. Now I'm dealing with a case with CPS. I was put on a child abuse and neglect registry, and I've never been told about it. I've never been served any papers about it. I wrote them an email and told them that they needed to take me off of it because they didn't follow due process. I was never charged with a crime. And I just found out that I have been on this list for 2 years, and nothing has ever, I've never, ever, no child abuse, no neglect, or no nothing like that. And I'm not sure where to turn to at this point.
Okay. The answer to that question is that's called libel, because it's a written affirmation and it's on paper. It's in record. That's libel. Okay. Slander is an oral defamation. So what you want to do is you want to inform them. You're going to, do you know who the agency is?
Yes, I do.
Okay. You're going to send them a notice of intent to file, and you're going to cite libel as the basis for your lawsuit, and you're going to sue them in federal court. Okay. Now, what's going to happen is they're going to ask what led to the libel, and that's where you can go in and you can tell your story. Okay.
Okay.
So the crime that they've committed is this libel, right? And if they benefited from this, and you can show they benefited from this, that's an unjust enrichment, right? Whether it was an advantage, a profit, or some form of gain by putting you on this list, and you can clearly cite what that was, that's called an emoluments violation, which is a constitutional issue. Because
okay, well, the question I got is they didn't gain nothing off of it. What it was my ex and me had gotten into an argument, and she had told me she was going to take my child from me and I'd never see him again. And so she went and told them, now I have over 83 pictures I just submitted in court. Like I said, I did a huge objection. I called out the judge. I called out the friend of the court. I pretty much put a little bit of fear into them, and that they were completely different when I went in to see them this last time. Now, but what she was trying to do is she kept bringing this up in court, saying, "Oh, he's on this list. He's on this list." And it's not stopping me from seeing my child now. Okay. So I don't understand what their gain would have been.
So what you're going to do is you're going to file two things. You're going to file a FOIA request with the agency.
A what?
A FOIA, FOIE, Freedom of Information Act request. Okay.
I already did that, and they wouldn't give me nothing. Okay.
Now, you've got a copy of that, yes?
I got a copy of where they said that they are not allowed to give it to me, yes.
Okay. You obviously have a copy of your original request, because those two things go together, right?
Yes.
Okay. That's, believe it or not, that's a piece of evidence, right? That tells a story. You asked them to do this, they refused, and they've got no just cause to refuse, right? So
right.
That is an artificial advantage that they gained outside of the law. That's a trespass of law. Okay? That's a cause of action.
Depriving you of exculpatory evidence.
Right. And that's where I'm going with that. Under Brady versus Maryland, Marbury versus, going back to Marbury versus Madison, they cannot withhold exculpatory evidence. So that's a definitive decision. We've already, basically, you're walking into court saying, look, we've already had this conversation and you can't do it. So because you're doing it, that's a cause of action for me, and to seek relief and remedy in the higher court. So in reference to your libel lawsuit, right? Because they won't even disclose what the nature of the libel is. Okay. This is what's called branding. This is a practice that we abolished in the late 1600s, right? By them bringing this up against you, and you don't even know this thing exists, okay, they can't define what the crime was. They've just put your name on this list and branded you without cause, okay?
Without due process of law.
Without due process of law. That gives them an artificial advantage, because what it does is, in the eyes of the court, is it attacks your integrity. Now, by attacking your integrity, your what's called good standing, okay, in the eyes of the court, you're technically not a believable person. And you can dispute that, okay? You can show, well, why am I on this list? What piece of evidence? Where's the crime scene? You know, like Kirk says, what procedure did you follow to put me on this list? Where is it in law that says that you have the right to put me on this list? And the answer is there is no answer. So,
not in law.
Correct. In these bills of attainder, which is what they were using, okay, which is probably why you're going to start seeing a whole lot of these lists go just completely away, and so they can try to hide the causes of action, which is another reason why we agreed to do this show. So because they've used it against you, and you can definitively show they've used it against you without any cause, that's a cause of I always call it reaction, because they took an action, you can take a reaction. And as long as you comply within the rules of court, that's where the 1983 comes in. So you deprived me of my life, liberty, and property by putting me on this list, which is libel on its face. I have a right to a cause of action to sue these actors, whoever they were, in federal court. And I have the right to seek relief and remedy. And you do.
Right.
So,
yeah, because I didn't know I was on this list, and I put in a job application to this one place, and they wouldn't hire me because of it.
I lost a 6-figure a year job because of the same bullshit. That's how I know how to do this.
See, now I was charged with one thing, which she came up with a charge. I guess they call it the silver bullet. She came up with a charge. Her and 3 other women sat there for 3 days and came up with this story. I ended up in jail. I went in on a domestic, and then 3 days later, I was looking at 5 felonies and life in prison. And they ended up releasing me 4 months later, but I had to plead to a charge that I didn't do because no one would fight it. Right. Then I get out and I try starting to see my son again, and no one ever told me I was on this list. They were making me pay $80 an hour to see my child.
Right.
And I couldn't afford it. My child snitched on them. I brought it up to the people that were supervising the visits. They canceled my visits. I spent about another year trying to figure out what I was going to do. And finally, I come up with a bunch of stuff and a bunch of evidence. I finally took it in front of the courts again. The referee blasted me. I objected to all her stuff that she blasted me with. I called out the judge himself. I called out the friend of the court, the people in the friend of the court. And then I found out that I'm on this registry.
Right.
And but it kind of blows my mind that the court's not paying no attention to this registry. If in all reality, if I was an abusive person to my son, why are they letting me see my son when I'm on this registry? And it's all because they know that I'm not.
Right. So
I've been getting punished for protecting my son. I've got 83 pictures of my 1.5-year-old son with black eyes, burn marks, missing toenails, missing fingernails, and no one will do anything. And it all comes when he's in her custody, and they're pissed off at me because I keep bringing this up.
Well, again, that's why I said, there's, ironically, when I started in this, it was my position was in my job was loss prevention, and I'm surprised how many parallels there are between what I did for a living and available mechanisms that we have to unscrew this problem. The thing that really bothers me is they've done such a success. They've over these, this last 100 years, 50 years, whatever it is. These lawyers have done a fantastic job of hiding all of this shit from all the people. Oh, watch the football game on Sunday or Monday or wherever the hell the day it is now, or they've got 300 things for you to do besides learn what you should know, which is the law. This is all stuff that
well, that's like I keep telling people that the only reason that things are starting to come to a head now is because we've got cell phones with video cameras and recorders and stuff on them, and people are starting to sneak them into the courtroom, and it's starting to catch them at their lies, and they're breaking the laws. It used to be that somebody would just walk out and go, "Oh, dude, you got screwed. Sorry about your luck."
Right.
Is there something we can do?
Yeah. Well, I really appreciate this help.
Either.
Is there something we can do while going into the lower court?
Like nobody's business.
Well, I lost my 23-year-old son 20 years ago, and I haven't seen him since he was 3 years old. And I didn't know no better back then. I lived in West Virginia, and they just said, this is what you're getting. And back in 95, I was paying $35 an hour to see my kid, driving 100 miles one way, and I was only making $6.26 an hour. And I couldn't afford it, and I had nowhere to turn when it all went awry. So I lost my oldest boy, but I got my 4.5-year-old here now, and I'm not going to quit the fight on him. He's the love of my life, and I'm a lot smarter now, and I've been battling for him for 4.5 years.
Yeah, well, like I said, that's a drop in the bucket for some of us, and that's. That's sad, but that's the way it is.
Yep. And I'm just trying to learn this stuff and expose these judges and do whatever I can to expose their lies and corruption. And I appreciate you guys helping me.
Should we be filing something when we go into the lower court? What's that saying? Or what's that motion?
Talking about judicial estoppel?
No. The appearance.
Special appearance?
Should we be filing special appearance as we go into the lower court?
Every time. Notice of special appearance. When you first get your paperwork, that's the only other thing you can file is a motion for continuance. You file anything else, you admit the jurisdiction. And they will run with it. Well, latches occurs.
Yeah.
You do not object to the jurisdiction. Latches occurs, and they go.
Because
you didn't object to the jurisdiction.
Most people
you didn't exercise your right to due process the law and raise your hand and object and give your affirmative defenses here.
No,
we're moving on.
But most people, they get this thing in the mail that says you have to be in court that day. They're not going to think to file anything.
You can bring it with you.
So what do I need to file?
Notice of special appearance, because you're appearing specially. The reason why you're appearing specially is because in most of these courts, they don't have proper jurisdiction. They're not competent courts with subject matter jurisdiction or personal jurisdiction over us. That's just part of the due process, of procedural process. And it's actually part of the substantive due process is your notice of special appearance. You're appearing specially, sometimes under threat of arrest if you don't appear. So with with my notice of special appearance, I have an affidavit of person. It informs them that I am sui juris, which means I am of lawful age of 21, that I'm of sound mind, and I am perfectly capable of handling my administrative duties under the law, which is my right to due process of law, which is to file my paperwork and make my arguments. That's my administrative duties.
Okay, so the first thing I want to do is the notice of special appearance.
And you can find that in your rules of procedure. Even crazier than that, here in Idaho, go right down to the court assistant's office and I can get a notice of appearance in propria persona.
So you're not technically filing in propria persona by filing special appearance, or are you?
You are filing in propria persona, in your proper person, and you're objecting to the jurisdiction. That's what in propria persona means. I am my proper person. I am not an artificial person. I am not a corporation. That's that all capital letters name that's on your paperwork. That's on your driver's license, your birth certificate. All of those, your credit cards and everything else, that all caps letters name, that's a corporation, a dead body. That's the language of the dead. That's called dog Latin. It's not English. The only
that's
thing,
the straw man, right?
Capital letters like that is at the cemetery on headstones. That is the language of the dead. Artificial person.
You're digging deep into history now, Kirk.
Yeah, I mean that's what it is. That's where we are being subjected to. The 14th Amendment allowed them to do this. That's what they've done. That's what the 14th Amendment did. Was it converted us all into chattel? Okay, we're slaves under the 14th Amendment. All of us. They don't discriminate on age, sex, or skin color. They convert us all of us into dead corpses, and the story is like this. Your birth certificate, you've been birthed like a ship, okay? And so you fill out that birth certificate, and it's actually a certificate of live birth, and it goes to the vital statistics, and you put normal writing in there. First letter is capitalized of your name, and then everything's lowercase. Okay. But when they process it, what they basically have said is they take you out to sea. So that puts you in maritime jurisdiction, maritime law, the law of contracts on the sea. Okay. And the proper jurisdiction to deal with contracts on the sea, because now you're lost at sea, according to them. Okay. You've been birthed and then you got lost at sea. So they're claiming you as dead, but they're issuing actually a death certificate to you, not a birth certificate. It's in all capital letters when you get it back. Like, wait a minute, do you guys not know how to spell, or is your typewriter broken? Is it stuck on cap lock, or what's going on over there? But that's the scam. And there's another term out there. It's called straw man. Okay.
Yep.
But that's it right there. It is an artificial person. Look up person in any dictionary. And this is even a crazy part. Even in your own statutes, even in some of the rules of procedures, we'll have definition of a person. Okay. And it says artificial person, an individual. We are man. We are creations of God. And that's what in propria persona means, is in our proper person as a man. And it's sui juris, which is lawful age, of sound mind. And then in personam is how you claim your rights, or deprivation of the rights. In propria persona is personal jurisdiction. I don't consent to this jurisdiction. I'm objecting to it, and here's my affirmative defenses. And then the in personam is, because you're subjecting me to this, I'm now claiming deprivations of rights. So if you want to continue here in this unlawful de facto kangaroo court jurisdiction, you have just created a right to a cause of action. And you are now a primary named defendant in a federal lawsuit. Have a nice day.
Well, let's take one. We have 3 more people on hold. Let's get, and 10 minutes
we are running out of
10
time.
o'clock.
See, this is why the story time doesn't work.
Right.
Because we got people that...
Let's try 5214. Hello, 5214. Welcome to Kirk, Chris, and Ted's excellent adventure call-in show. Who are we speaking with, please?
Alex.
Hey, Alex. What's your question?
Well, listen, I have a hearing, but it's not in family court, but it's for child support. It's not for my case itself. So I kind of gave up on it. And so I've been listening to you guys this whole time today. This is probably the longest I've listened to it, because I think today was the first time that I was able to listen in and actually catch on some of the terminology that you guys were talking, because it wasn't so advanced.
Right.
So say again.
I just said right, except for certiorari. Kirk's still working on that one.
Yeah. I mean, I get where you guys are at, where you guys are coming from, but I'm going to keep it short anyways. So I have this case, this hearing for child support, and of course they're asking for child support from me, and of course I haven't been giving them shit. I'm not going to give them anything, and so I don't know what to do, because I want to start seeing my son again, and I want to start fighting for the case again. But I don't know what I can expect from that hearing and what they can do, as far as actions against me. What should I expect?
Well, the first thing is it's not your right to see your son. It's your son's right to see his dad. So if they're depriving your son to see you, then that's a deprivation of rights right there, and you can go to the higher court immediately.
Mm-hmm.
What's the higher court?
The appellate court or the federal court, depends on which way you want to go. I mean, deprivation of rights is an automatic civil rights violation under Title 42, Section 1983. And then, this is what I love about Chris Hallett and what his work is all about, is the emoluments. Actually, it's emoluments. I make it a funny there, because it took me quite a while to, I don't know how long, saying emoluments. but it's emoluments, and it's that one word that comes after that title of nobility in the Constitution for the United States of America in Article 1, Section 8, Clause 9.
Section 9, Clause 8,
Section
but
9, Clause, yeah.
Okay, so let's say I want to go to federal. What should I do, and what should I file, and where should I go?
Yeah. Well, United States Code. You pull up United States Code, law.cornell.edu, and you get the law there, and you click on U.S. Code, and you go to Title 42, and you go to Section 1983, and you read all of that, which, I mean, there's not a whole lot there to read, really, but it's hard reading, so you have to, for me even, okay, a guy can read 400 words per minute with better than 85% comprehension. I have to slow down. I have to read, sometimes several times, sometimes ask somebody else, what the hell does this mean? Because sometimes I don't. So take your time, read it as many times as you need to, and then in the same place, law.cornell.edu, you go back over there to get the law, and you'll go to the Federal Rules of Civil Procedure, okay? And you can go in there, and that tells you how to do everything from beginning to end in the federal rules. How to practice in federal court.
Is it understandable for somebody like me that's kindergarten level as far as law?
I've seen some pretty damn smart fifth graders out there, so I'm gonna say yes.
He's saying
this is what we're here for. This is what we're here for. Okay, so if you go in there and you start see this is the thing. We need you to read it because we can't sit here and read it to you, and you're not going to understand when we say file a notice of special appearance or file a writ of certiorari. That one
easy for you to say.
Yeah, right. So if we could get you folks to read it, okay, and if you come across something and say, okay, well, Rule 4.1, declaratory judgment, or is it 5.1, Federal Rule of Civil Procedure, I want to do a declaratory judgment, and I want to challenge the statute itself as being unconstitutional. How do I do that? Well, if you haven't read the Federal Rules of Civil Procedure, Rule 5, it's gonna be kind of hard for us to explain it to you. So it would behoove you folks out there, all of us. I'm guilty of it too. Don't read it. So I mean, I read a lot of stuff. So sometimes I don't read what I should be reading, but my brain goes 110 miles an hour sometimes, and I get sidetracked. Ooh, shiny wet squirrel. Seriously, we need to just read this stuff. It's there. It's out there on. That's the nice thing about the internet and the information highway that's out there. It's fairly simple there, and some of the stuff out there will have forms right there. I mean, my Idaho stuff has forms right there on my rules of procedure for not criminal stuff, but the family law stuff and some of the civil law stuff. And then our court assistance office will have some documents. So I don't know, not everybody has that. It's funny that I'm out here in Idaho, potato farmer land, a bunch of rednecks out here, and we're usually, 20 years behind the times, but it seems that some other places are really dark when it comes to assisting the people and helping them, aiding them, and actually defending themselves in court. But there again, they don't want you to defend yourself. They want you to hire an attorney. So the attorney will go in there and admit the jurisdiction, take leave so that everything that happens here happens to you. And by the way, an attorney is to attorn you, which is take your stuff and give it to somebody else, including lining their own frickin' pockets with your money and giving your stuff to somebody else. So, yeah, again, it would behoove us to read this stuff. I love that word. Somebody else earlier said.
So let's say I read it, and then I follow their little template guide or whatever. And then I just file those things. So what about my child support hearing? What should I expect?
Your what?
Child support.
My child support hearing.
Child support hearing? So is that like for failure to pay child support?
No, determination to what he's going to pay. Otherwise, it would be contempt.
Oh, so okay, so you have a determination and you've had a schedule and all of that stuff?
Yes.
Okay. What's it based off of?
Based off my VA disability money.
There's your answer right there. You need to talk to Jay Moss. He's having some.
Jay Moss did not have any luck, bro.
No, he got an attorney. I found out
he denied him.
Huh?
Well, no, that's right. I did catch that. He's something about he's got some pro bono attorney now, right?
Yeah. I just caught the video of that just like yesterday. You know, right. I'm trying to watch stuff and I'm like playing catch up. But I heard he's got somebody fairly decent, and this person that he's working with is he got through. I think either buying through the VA or anyway, it's the person's affiliated with the VA somehow.
Right.
So,
but nothing so far about his case.
Well, I mean, yeah, my understanding though is the guy is good. So, right. But because it's VA benefits, that's, you know, so somebody who's military would probably do better to deal with the military benefit end of that, because that's stuff that I never dove into that.
It's very similar to.
I've spoken with Jay Moss, right, and you know, it seems like his information does not apply to me because, you know, the VA is not apportioning my money, so they denied. You know, I was able to prove that, you know, that money is going to be unjustly taken. They took it, my appeal, and I won, and so the VA is not giving them any money. So I haven't given them any child support money. So now they decided to go through the family court instead, and now the family court gave me a hearing date, which is coming up in about 2 weeks or a week, and so this is not a VA problem issue. Now
right.
This is a
but the family court will take your money.
Well, it doesn't matter if they want to call it family court or they want to call it the, you know, the whatever the hell they want to call it. They're still attempting to take money that's not, that they don't have a right to, right? Because that's your military benefit, correct?
Right.
Okay. So it doesn't matter what courtroom they want to go into. It does. It's irrelevant. They don't have standing to take it. If my loose interpretation of what I've been playing catch up with is correct.
Let me bring Darren on, because Darren's actually done quite a bit of this stuff.
Oh, good.
Darren? Well.
Hello, I'm here.
Okay.
Well, I just have a suggestion to this man. They've already made a determination. The VA's already said we're not giving them the money. So what they're trying to do is bring you back in so you can give them information that they can go after again.
Mm-hmm.
That's what it sounds like to me. So in my opinion, I would not open my mouth in court and give them any information that can be used against you to attach anything. If they have some kind of a claim, you can make them prove that whatever they're saying is true. Just tell them, look, I'm unaware of any of this. If you have evidence to support what you're saying, please present it to me, and I will confirm or deny whatever it is you're showing me. But they won't have any of that. So don't tell them I get this much from VA. Don't tell them anything. Yeah. Don't tell them where you live. Don't tell them anything.
Burden of proof is on the moving party.
I'm here under the and I'm going to exercise my Fifth Amendment rights without counsel, and I'm not speaking. Plain and simple. And that way, you know, if they're not touching it, they're not able to get it. Then as soon as you give them any piece of information that they can go after, they will take it.
Right, okay, right. That's just, they already have that information.
Okay, the VA's already stopped them, right? The VA is not cooperating. Okay, then I'm unaware of any valid order that says you have any right to take my money. The VA supports that, and that's all I have to say about that.
Family court is still going to take it. Doesn't matter if you open your mouth or not.
The VA has already said, no, you aren't taking it.
Family court doesn't go by the law.
Well,
you've got to remember who
I don't consent to this jurisdiction.
VA is federal, so when the state tries to tell the federal to do something and the VA says, no, fuck off, and you want to try and come back and do it again anyway, they're going to find their ass in trouble.
It'll be interesting in this case.
Don't fill out any of their paperwork.
No.
Don't do anything. Don't give them anything.
Right.
Don't sign nothing.
In fact, he would want to, before going into court, he would want to file, I can't think of it again.
Notice of special appearance.
Correct. A notice of special appearance, because if you walk into that family court, caller, if you walk into that family court, you automatically give them jurisdiction unless you file special appearance.
Explaining that
how do
you
I
don't
do that?
consent to the jurisdiction.
Correct.
And how do I do that? Where do I file that?
That would be with the clerk of the court. With your notice of special appearance is an actual court document with the case number on it, and I don't know how your court documents are laid out in your state.
So let's say I do that. Would I still have to attend the hearing?
Oh yes, yeah. But what a notice of special appearances is, all right, hey, I'm appearing because you've sent me this summons, but this is by special appearance.
I'm not signing your contract.
Your orders, okay?
Right.
Under your subpoena, okay? I'm appearing.
What did I expect?
Specially.
Can we just stop for 1 second and let me explain that there are questions that they're going to ask you that will actually bring you into their jurisdiction.
Yes.
They're going to ask you, are you so-and-so, whatever your name is? And you're going to say, you're going to have to know how to answer that. Do you understand why you're here? You're going to have to be able to answer that correctly. Otherwise, they're going to trap you into their jurisdiction.
Yep.
That's things that are very basic that many people don't know and maybe should be something that we talk about, just like baby steps towards keeping yourself free. The first thing you got to remember is you have the right to remain silent. You have the right not to present any evidence that will incriminate you. If they have a claim that they're bringing, you make them do all the presenting. But you have to do it in a certain way. You can't just say, no, your answer is going to be, I'm unaware of any evidence that supports this claim. Can I be presented with that evidence? You got to put it in the form of a question and put the burden back on them. That's how you have to do it. I mean, you got to be careful because, like I said, very simple questions. You're going to be tempted to answer honestly because that's what we do as our nature. Are you so-and-so? Yes, I am. Well, you screwed yourself right there.
Right. So what you're saying, Darren, is every time you answer them, you need to answer them in a form of a question. Usually when you're in public, if I ask somebody a question and they answer me with a question, I'm like, hey, motherfucker, I'm sorry. I asked you the question first, but that's not how it works in court. You need to answer every question with a question. It's like a rule.
Honestly,
otherwise,
if you don't quite know what you're doing there and they're asking you all these questions, most of the time the answer is no. I don't understand. No,
exactly.
I don't understand. No, I don't understand. All I understand is you don't have personal jurisdiction here. You don't have subject matter jurisdiction here. And the burden of proof is on the moving party. So the moving party needs to get moving on proving this personal jurisdiction that gives them standing to bring this action against me. And make those statements.
One more thing to remember is that when the moving party is talking, you need to be listening. Because if they say, you live in the city of so-and-so, you need to object. Objection, Your Honor. The plaintiff is trying to assert facts not in evidence. Plain and simple. You have to listen to what they're saying.
Versus Pagliaro. While enlightening to the court, or statements made by attorneys may be enlightening to the court, but they are not facts on the record.
Yeah, something I used to always tell people before I understood what was going on. Whenever the opposing counsel opens their mouth, what I used to think was just say objection automatically because you don't know what's going on. But what Kirk and Darren is saying is how you object.
I mean, you can say I object, but the judge is going to say on what grounds, and then you can say the plaintiff is attempting to assert facts not in evidence.
That's
plain and simple. That you're done right there. They have to go. It goes right back to the plaintiff.
So what are they going to do in that instance when I say that, or what should I expect?
Well, you should expect the judge to say to the plaintiff, whoever it is, do you have any evidence to support what you just said? Can I see the evidence? Can you present the evidence to you? You know, because honestly, you're basically throwing the burden on them. They have to prove everything they say, everything,
even where you
live.
What
if they don't? What? Because you know, I can tell by, and I'm going to have the same judge. I can tell that she's very biased, and nothing has worked in the past, and it just gets blown in my face, and every time I.
All right,
that's when you have a Title 42, Section 83, 1983.
Right.
As soon as
I'm the plaintiff. I'm the plaintiff, and you're the defendant right now. The plaintiff talks first. They come in. They say, "Okay, this is William T. Smith, the defendant. He lives at 123 Anytime Street in Oklahoma, USA." Okay, they just admitted a whole bunch of facts right there. You have to be able to object to that if anything in there is incorrect. And then, okay, so let's just say your address was somewhat correct or whatever. You still can object to it and make them put it in evidence. Make them show where they got it. Then they're going to say the defendant is on VA disability and he brings home an income of $1,600 a month on a weekly basis, yada, yada, yada. And you're going to have to say, I object, Your Honor. The plaintiff is asserting facts, not in evidence. If you do that 2 or 3 times to them, they're going to throw the case out because they don't have the evidence. They're relying on you to confirm and not object.
So with that right there, every time that they make statements like that, okay, statements on the record, left unrebutted or objected to, become facts on the record. So exactly what Darren says, I can say whatever I want about you. I could say you've got a green horn growing out of your tail and blah, blah, blah. And, well, I just said that because of what Crystal just said. Anyway, if I could say whatever I want, is it true? Is it factual? Do I have evidence to support those statements and claims? Probably not.
If it's unrebutted, it becomes.
So now we're talking about whether it's the judge or anybody speaking in the courtroom, right? I can object to any of them, right?
Mm-hmm.
Well, anyone who's asserting facts without evidence.
Okay, that helps.
And here's the thing: if the judge lets it go through with no evidence, then that's a deprivation of rights, and that's why, like we were saying about an hour before, you need to have your paperwork ready to file an appeal under Title 42, Section 1983, 85, 86, correct?
Right.
Because as soon as they open their mouth saying, like, I don't care about your objection, you hand them this paperwork saying that you're filing an appeal in the higher court.
But see, you won't even get to appeal if you make the proper objections in the start. The judge is going to see what you're doing. They're going to know what you're doing, and they're not going to try to bulldoze over you because they're going to see you're setting them up for an appeal and a lawsuit.
That's if the judge understands anything we're talking about. Most of these family court judges are appointed, not elected. They know the law less than we do.
Right, but you start doing what Darren and I are talking about is, where's the evidence to support that? Where's the evidence to support that? And like Darren said, 2 or 3 times. And that's what it takes. Usually by the 3rd time that you do something in a row, the judge is going to go, the first time is going to be like, yeah, whatever, The second time he'd be like, what's going on over here? The 3rd time the judge is going to go, you know what? I think I'm going to step away from this. Just like my judge. Okay, it took me 3 times.
I would hope so, but some of these family court judges, like he's saying, is bringing up stuff that it just doesn't make any sense. They don't know what they're doing. These judges.
Here's another thing,
right? But then you put them on the hook.
What if they don't know? What if they don't know what they're doing, and they proceed with XYZ. So
that's what I'm worried about.
We could what if all night long, but when it comes to, this is another difference between paper law and trial law. If you're going to make an oral objection, you're going to take, every time you do that, you're going to have a pad in front of you. Take a legal pad with you and write down what your objection was, okay, and what was said after your objection. And what you're going to do is you're going to ask the court, if it pleases the court, I can put this down into a formal document and file it with the clerk for the official record if the court wishes me to. Even if the judge says, no, you don't have to, you're going to do it anyway.
Right.
So this way, you're creating an official paper record in addition to the oral argument. So if you do have to go to appeal, you can, the oral argument kind of mysteriously disappears. It's still on the record. And you can say, well, I did object to this. And the reason I know that is because I did, I filed this document based on my notes from that day in court. What happened to the transcript? And the reason I know they do this crap is because they pulled it on me. And what they don't know is I was smart enough to document everything, and now I've caught them on it. So, and again, that's all in the case. But there's a right way and a wrong way to do it. And if you ask the court, you're basically telling the court, look, if this pleases the court, I'm going to file this not only orally but in a written format. It lets them know that if they screw with the record, it's going to be documented, and somebody's going to jail.
Okay.
So
there's been a couple questions here online. Has anybody done any of this stuff and that kind of stuff? Okay, I'm gonna tell you my little story that happened here in family court. Okay, I was court ordered to go to a parenting class by the judge. Okay, as per our divorce, which there was never a marriage. We never were married, no marriage contract or anything like that. But I had an attorney. Paid him $2,500 retainer, $200 an hour. Okay, supposed to be a really good attorney. This is my second one. Like, oh yeah, I'm really gonna get my child now, you know. So I get this contempt of court hearing. Okay, so I go in and I show up, and my attorney's there, and he's like, oh, why didn't you go to the class? Why didn't you go to the class? I said, where do you want me to start? He's like, what do you mean? I'm like, first of all, where's the delegation of authority for her to tell me I have to go to this class? He's like, what do you mean? I'm like, well, isn't that a deprivation of my life? I said, judge is trying to tell me I have to go and get educated by these people. And then he's like, okay. And then I said, well, then that's a deprivation of my right to liberty, because judge is telling me I have to go incarcerate myself for 2.5 hours to get brainwashed by these people. And he's like, And I said, then it's a deprivation of my right to property, because the judge is telling me I have to pay $50 to go incarcerate myself for 2.5 hours to get brainwashed by these people. And I said, so there's 3 deprivations of rights all in one, just in the court order. And so my attorney's like, well, I think I'm going to let you talk to the judge when we get in there. Okay. So I get in there, and the judge is like, okay, so what's going on here? And my attorney's like, well, I'm going to let him talk. And the judge is like, huh? What? A paid attorney sitting here next to him, and you're going to be a paid attorney is going to say, you're going to let your client talk? And he's like, yeah, I'm going to let him talk. So the first thing I asked was, do you have your oath of office on file? Do you have your surety bond on file? Is this a court of law, or is this a court of equity? Okay. Those are the very first 4 questions I asked. And the reason why is because courts of law is what we're actually, the jurisdiction that we laid down and ordained and established as law in Article 3. Courts of law, the common law, okay, and courts of equity. That's the only 2 courts that we laid down, ordained, and established as law. So that automatically put the judge on some sort of notice, because she perked right up and she's like, well, I think I'm going to find you in contempt of court. And I said, well, Your Honor, I said, I'm claiming usurpation of power here. I said, where's the proper delegation of authority for you to tell me I have to go to this class? And she looks down over here and well, the legislature of state of Idaho and the Supreme Court of state of Idaho says so. And I said, since when does the legislature of the state of Idaho and the Supreme Court of the state of Idaho have the authority to make law that's in violation of the law? And she just kind of looked at me, and I said, again, you have your oath of office on file. You have your surety on.
We've got some
what
feedback.
What the heck is going on?
Yeah.
Mute your mics over there, please. Thank you.
It's Zoom. Zoom's getting
I got everybody muted, but that's still not. So from there, the judge was kind of fidgeting in her chair and stuff, and I stayed calm just like I am right now. I'm claiming usurpation of power here. I claim deprivation of my right to life. I claim deprivation of my right to liberty. I claim the deprivation of my right to property. And she's like, well, I'm just going to go ahead and find you in contempt of court. And the bailiff, she'd already pushed the button over there trying to get that bailiff up there. Bailiff comes up and says, I'm just going to find you in contempt of court. And I said, well, Your Honor, I said, we haven't even gotten to jurisdiction yet. And she just got that she crooked her head and looked at me and looked at my attorney. And she's like, you know what? I think I'm going to go ahead and dismiss this. Okay? Because I've already stated on the record that, first of all, where's your oath of office? Make sure you got your surety bond on file. And is this a court of law or a court of equity? I'm demanding the nature and the cause of action here is what I'm actually demanding. You have the right to demand to know the nature and the cause of action of why you are in court. Okay? So contempts of court, technically speaking, are criminal in nature. They are not civil in nature. So you find yourself in a family law court under contempt of court. There's your objection and affirmative defenses to lack of jurisdiction because it's criminal in nature. Now, I didn't even have to bring it up because in my family law rules of procedure, Rule 101, specifically says they don't have jurisdiction over contempt hearings. But yet, here I was in a family law court telling me that I'm in contempt of...
These are not civil matters, they're criminal matters.
Man, I don't know what's going on there.
So we are at the 2 hour and, let's see, 7 minute mark. Do we want to continue, or are we can't talk, or are we finishing up here?
I think we'll end that for tonight, right there. But I want you to understand, you have to articulate this stuff. And you heard what I just said. It's not that hard to make those statements. I even had the judge tell me, well, you don't have the right to ask me questions. And I said, I most certainly do have every right to ask you questions. I have every right to make my defense how I see fit.
Where is the misunderstanding of the definition of inalienable right?
Unalienable. Unalienable right. Where's the misunderstanding of an unalienable right? Unalienable. Where is the misunderstanding, he's asking? There shouldn't be a misunderstanding. It's the lower court.
Unalienable rights are creator-endowed rights, fundamental rights for the law of nature as natural rights, which have nothing to do with the establishment, support, or management of government.
Right.
Which is exactly what I keep putting out there, that marital rights and parental rights come from the law of nature as natural rights. I have American jurisprudence on it. I put it out there. It's in my Kirk's Law Corner group. It's in a PDF. I put it on Amber and Stevens. I put it out there several times.
The thing is,
what is the interpretation of inalienable right?
well, the thing is that you're not going to get justice in a lower court.
Correct. Because here's why. The question you need to ask in an equity court, there are two forms of equity. Equity meaning equality, and equity meaning money. Right? So you also can clarify, is this a court of equity meaning equality, or a court of equity meaning money? Because if it's money, that's probate court. Right? So,
well, the thing is, it's you that have to make your statements. It's you that have to make the objections and affirmative defenses. It's your duty. That's what due process of law is.
Right.
You stand there and tell them what you due process of law.
Yeah. Tell them what you want, why you want it.
And I don't care what the judge does. Don't care what that judge does. Don't buy into the emotional side of things when they try to stir you up. You just kind of keep your calm. You know, try to stay calm and focus. Focus on making your statements, and that's it. Don't agree with anything. Don't sign anything. You know, drop this stuff down and lay it on them. This is it. This is what the law says. I don't care if you agree with it or not. And if you want to deny here, that's an appealable issue. And now, if you deny me any of my creator endowed rights, unalienable rights, you are now going to be a primary named defendant in a federal lawsuit.
That's why you have to have these appeals ready to go. You're not going to get justice in the lower
ready,
court.
Guys. Have them ready before you walk into court.
Yep.
That's what the lawyers do.
All right, any last statements before we head out for the night? Chris, Kirk, myself?
Well, my phone's ringing, so...
Read the rules of procedure.
Hold on.
Read the Declaration of Independence. Read the Constitution, the state Constitution. Read the Supreme Constitution.
That is correct. Yep, know what it says before you walk in the door.
Know what your rights are, where they come from in law, so that you can effectively claim them, which is judicial notice. I put you on judicial notice, Your Honor. The Declaration of Independence says I have greater endowed rights. Those are unalienable rights, which actually have nothing to do with the establishment, which is legislative branch, support, which is the executive branch, or management, which happens to be the judicial branch of government. You have no delegation of authority here, period. No jurisdiction.
And also, that same document says that I have a duty to make sure that you don't trespass upon those. And that duty is protected by the 9th Amendment.
Correct.
Great show, guys. I think keeping it very simple and reiterating these facts that the lower courts will never give you justice. I think that's what we need to repeat, rinse and repeat over and over again. Even give it, we need to give a template to people saying like, here, bring this to court with you the first time. As soon as the judge deprives you of anything, hand it to him, and then go file it. Oh.
Yep.
That's it.
And equity money, which is probate court. Okay.
I think Chris is on the call.
Yeah. So good night, everybody.
Yes, thank you for tuning in. Like, follow, share Kirk's Law Corner, the March Us. Thank you, Ted, for everything that you do over there. He makes all this happen. He's the techie guy over there. So it's a lot of work. Thank you, Ted, for doing what you do. Much love and respect over there. Thank you, Chris, for coming on. Darren coming on. Thank you, callers that are coming on. You know, we're trying to make this show about you. You know, your questions. Francesca has her shared for parenting or whatever that She has a deal there. If you want to go tell your story about your case, she's the gal to go see. Lady, woman, say gal, G-A-L. Redneck in me, call them gals around here. Man, read, folks. We need to get educated. All of us. You know what it says. Love you all.
The juvenile justice system and its shocking power.
And now this family, without a single allegation of abuse or neglect or even a failed drug test, have lost their 2 boys to DCS.
I always sing "You Are My Sunshine," and he always holds my hair, kind of like this. It's just a thing that he's always done. So when I got my son back, my son then, because he was used to doing that, had held his own hair up right here on the top, and he had held it and pulled it so much that he has a huge bald spot.
Criminals have more rights and more protections than parents.
DCS secretly went to Williamson County Juvenile Judge Sharon Guffey and asked for an ex parte order to get custody of those kids. They are going into foster care that night.
I am so excited to have Tori Harper on the Marches Live to welcome her into our family law reform community, along with her lawyer, our very own Connie Reguly. I can't thank the people at Fox 17 enough for one of the best reports I have ever seen regarding a topic we are dealing with on a daily basis. Please join us this Thursday.